Uh, Chinese and I will speak on ICL issues in Russia-Ukraine conflict in the context of the politics of the ICC. On 24 February 2022, Russia invaded Ukraine in an escalation of tension and conflict that is believed to have begun as far back as 2014 with Russia's occupation and annexation of Crimea. The gravity of the attack and its illegal nature caused many national governments, NGOs, and international institutions to demand legal investigations into the invasion. The illegality lies in that Russia's attack was in direct violation of Article 2.4 of the UN Charter, which prohibits the threat or use of force against the territorial integrity of another state. International criminal law regards certain conduct, including war crimes, crimes of aggression, crimes against peace, and crimes against humanity, as particularly grave enough to constitute international crimes, holding perpetrators of such crimes individually criminally liable. The conduct of war and the humanitarian treatment of persons during war are all legitimate concerns of international criminal law. Concern was also raised regarding how Russian forces purposefully targeted civilian infrastructure and armed combatants, including children and women. The ICC prosecutor announced soon after the invasion that it would seek authorization to open investigations into the situation in Ukraine. This approach, known as the investigations proprio motu, is provided for in Article 13 of the Rome Statute, and it is one of three mechanisms by which the jurisdiction of the ICC is triggered. The other two being referred by signatures of the state of the Rome Statute and referred by the Security Council. As of the 2nd of March 2022, 40 countries had reportedly referred the situation in Ukraine to the court. ICC prosecutor had also announced that he would open investigations into possible war crimes against humanity and genocide on the territory of Ukraine committed by an individual since 21 November 2013. A year later, in 2023, the prosecutor of the ICC announced arrest warrants for Russian President and Russian Commissioner of Children's Rights on all crimes of deporting and transferring children as they are afforded special protection under the Geneva Conventions. The UN Independent International Commission of Inquiry on Ukraine it also issued reports detailing, among other transgressions, unlawful confinement and forcible transfers of Ukrainians by Russian forces. The reports recounted confinement of large numbers of men, women, and children without any access to judicial process. Their subsequent forcible transfer to other parts of Ukraine and ultimately their deportation through Belarus or directly to Russia. More recently, on about 5 March 2024, the ICC prosecutor also announced the issue of arrest warrants for 2 Russian military leaders in relation to attacks on civilian objects and excessive harm to civilians in attacks, emphasizing that those responsible for actions that impact innocent civilians or protected objects must know that all wars have rules which bind all without exception, and that this applies to the situation in Ukraine as in all situations for which its office has jurisdiction. However, there's a problem from an international criminal justice perspective in that the ICC cannot prosecute for what Sperry describes as the mother crime, namely the crime of aggression in Ukraine, which scholars argue that it enabled the other crimes which the ICC prosecutor says he is investigating later during the Ukraine war. Prosecution for the crime of aggression, as the argument goes, will be necessary to hold the Russian government officials accountable as the persons who started this war in the first place. This is because in terms of Article 8.1 of the Rome Statute, the crime of aggression applies exclusively to political military leaders and not, for example, to lower-ranked soldiers committing war crimes. Ukraine and Russia are not ICC members, and Russia has veto power in the Security Council, and therein lies the element of the politics of international criminal law. Consequently, the ICC will not be able to prosecute Russian senior government officials such as President Putin, Foreign Minister Sergei Lavrov, or high-ranking military officials for the crime of aggression. This illustrates the stark reality of the politics of international criminal justice and how it may materially affect effective enforcement of international criminal law. It has been argued that the real problem with holding Russian officials accountable in the circumstances lies in finding an entity that can legally conduct investigations and prosecute for the offences, because the ICC is critically handicapped to effectively deal with peculiar circumstances involved in the Russian-Ukraine war. While calls have been made for the establishment of a special international tribunal focusing on the crime of aggression in the Ukraine war, since the ICC does not have jurisdiction over this crime in Ukraine's territory, it is not without its own controversy. In any event, it is difficult to see how this will materialize when the UNSC itself, which would have responsibility for doing so, is compromised. One author observes the possibility of establishing international tribunal in the circumstances would likely receive support from most Western-oriented governments, but not more. He notes that among resource problems and competition with the ICC, this court would also bring severe political complications, mainly because of the already widespread perception that international criminal justice is a selective tool of the West, so-called lawfare, whenever its interests are at stake. Suffice to say, as Dawkins put it, ultimately, international courts tend to reflect the political dynamics of the world rather than alter it. Many countries may disapprove of Russia's actions, but none outside the West and its closest allies in Asia are prepared to make this central reference point of their foreign policy.
Okay, thank you so much, Evans. Just take note that as regards the establishment of that special tribunal, we've got other scholars such as Professor Yella, who argue that the establishment of that tribunal raises serious questions of selective criminal justice, given that the crime of aggression has not been prosecuted since World War II. And this, I believe, may align well to the notion of those who are behind or who are financing the conflict. We are looking at the United States of America and other regional arrangements such as the European Union, who obviously would want to advance their national interests and foreign policies in a bid to settle scores with Russia for other issues which are totally unrelated to the conflict we are talking about. The ICC has also been marked by double standards in the enforcement of international criminal law, including a lack of accountability on powerful states. And this has created a culture of impunity which has cast a shadow on the very notion of why international criminal law matters. Whilst we acknowledge that it is a product of destruction or war, it should be seen as a move on renewal or moral renewal and giving hope to the affected victims, but that has not been the position ever since. Also take note that the International Criminal Court is facing serious challenges in arresting and prosecuting heads of states, officials and other military commanders who are alleged to have committed these international crimes. And this has manifested itself in the ICC's previous efforts in that regards, where it has tried to find or to hold these leaders accountable before. In its efforts initially, we've seen that it has given heads of states warrants of arrest, but this has not yielded much results. And a critical example in this case may relate to the case of Omar al-Bashir and Muammar Gaddafi, and even the recent case of a warrant of arrest being given to the president of Russia, which is Vladimir Putin. And also you will note that the ICC still lacks jurisdiction over this most important leadership crime of aggression, and this has helped create a fatal gap in the overall accountability prism. And this has been worsened by the existence of even cyber warfare and the committee of digital crimes, given that still international criminal law still lags behind. The manifestation of cyber warfare and committee of digital crimes in this conflict has manifested through hacking and disinformation, which has been significant in the conflict. And the fact that international criminal law lags behind in this regard means that as regards the aspect of accountability, there is still a lot to be done in this regard. And therefore, the pursuit of accountability as regards international crimes committed in Ukraine still has been complicated by various political considerations and challenges. And here we are looking at the United Security Council dynamics, geopolitical tensions and rivalries, the nation of states prioritizing national interests and foreign policy, and also the role that is played by international organizations and institutions in conflicts. Under the United Nations Security Council dynamics, we take note that this has been complicated by the permanent membership of Russia in the United Nations Security Council, because it has vetoed Ukraine-related resolutions with much support from China. And also under geopolitical tensions and rivalries, you find that this conflict has been regarded by many as a proxy war between Russia and the West, with also support for the affected Ukraine being be coming from the United States of America, the EU, and NATO. And as such, this is posed as a serious challenge to the existing tensions that are already existing between Russia and the West. And this has serious implications for global stability and security, and has also caused a shift in global power dynamics. As regards the notion of states prioritizing national interests and foreign policy, it has become clear that countries' responses to the conflict are shaped by their national interests, foreign policy priorities, and also strategic alliances. And this has become so much evident in this conflict. We've also seen the role of international organizations and institutions, which have become very much ineffective in trying to resolve this conflict. In conclusion, we may simply say that there is therefore a great need for a comprehensive regime of accountability which is capable of fulfilling the goals of international criminal justice, which include prosecuting those responsible for the atrocities which have been committed, and that is to extend to those who are also financing the conflict. And it must also include advancing the expressive goals of international criminal law, sending a global deterrence message through the sentence that is going to be given to these perpetrators, and contributing to the resolution of an ongoing conflict. But it also does not end there. There is need that they should be brought out national reconciliation and healing, because victim rights and reparations are essential, as is justice and accountability as drivers of lasting real peace.